Hi. I'm going to talk about two different things. The first one is improving provision of counsel in misdemeanor cases and the work that I've been doing in Washington and other places. And I call this 11 years and 6 minutes because I started doing this as a Soros Fellow in 2003 or 2002. And then the other part is how we develop standards, and we now have a court rule requiring standards, including caseload limits. And that's been 34 years. And so I'm going to cover 34 years in 6 minutes. And so I thought about 30-minute Shakespeare, those of you that have had that experience. And I put a little map up here because I know when I lived in New Jersey, I really didn't know very much about where Washington State was. And for those of you that are familiar with the New Yorker covers, so I just wanted to make sure you knew where we are. Norm Lefstein produced this work called Justice Denied about how prosecutors negotiate plea arrangements with accused people who are not represented by counsel and have not validly waived their right to counsel. And I didn't realize that that was going on in Washington State because when I grew up practicing in Seattle, we had lawyers all the time at arraignments. But a friend of mine became a judge, and he said, "Bob, you have to look into this." And so that's what I've been doing. Counsel is often not provided or provided late. Sometimes people who are eligible don't get lawyers even when they ask for them, just like Gideon. And very often the court runs through a so-called waiver of counsel in literally a minute or less. After Gideon, there was a case called Argersinger, which is what established the right to counsel in state misdemeanor courts. And back then, 40 years ago, the court talked about the volume of misdemeanor cases far greater than felonies, creating an obsession for speedy dispositions. The ABA 10 principles that Anthony talk about assigning counsel as soon as possible. The scope of the problem is truly enormous. There are 10 million misdemeanor cases a year, and I've seen estimates as high as $1,600 a case in Oregon to process a misdemeanor. So what I talk about is $1,000 because it's easier for people to grasp. But of course, that means you're looking at unbelievable amounts of money. In Texas, where I spoke a couple years ago, they have at any given point 11,000 people in misdemeanor jails, which cost them $180 million a year. And in Washington State, where we have, I think, something like 7 million people, we have almost 280,000 misdemeanor cases a year, which is one for every 24 people who live in the state. And when you consider that includes children who are not yet being charged with misdemeanors, almost everybody knows somebody who's been charged with a crime. And I'm sure if I ask people in this room, aside from clients, you know people who've been charged with a misdemeanor, whether it's possession of alcohol as a college student or shoplifting or drunk driving or something else. And of course, these are way more numerous than the felony and juvenile cases. As Sasha's going to talk about, I think even more, the consequences of conviction are really difficult. difficult. You can get kicked out of the country if you're not a citizen, you lose your job, not get a student loan, lose housing, and of course that can affect your family as well. And then the fines and costs are often astronomical. We have made some progress, and that's, I think, one reason that I was asked to talk about this, because we've come up with some ways to get the misdemeanor cases out of the system and also to get lawyers for people at arraignment. In King County and the city of Seattle, we have diversion programs for suspended driver license cases. And the city of Spokane has reduced their misdemeanor case side by 1/3. And when you think about it, their public defenders were doing 600 cases a year. Now they're doing 400, just because they took the driver license cases out of the system, help people get their licenses back, then they pay the fines that they owe, and so you actually make money on it. We, of course, have reclassified marijuana, and before that we had a city attorney in Seattle who stopped prosecuting those cases. And I've been able, in some places, to get lawyers at arraignment, which I'll talk about a little bit more. We still have a lot of issues. We have high-volume calendars with either no lawyers or overwhelmed lawyers. We still have prosecutors negotiating with unrepresented defendants. We have waivers of counsel and guilty pleas that follow them that would not stand up in an appellate court. There's excessive caseload, lack of resources, and overwhelming volume. One thing that I've been actually interested in for a long, long time is getting cases out of the system altogether without even diversion, just reclassifying them. In Texas, they arrest 140,000 people a year for drunkenness. That's a public health problem and shouldn't be in the courts. This guy, back in 1973, wrote an article about how we should stop prosecuting what he called victimless crimes. And then I wrote a similar paper in a much more scholarly way, perhaps, but with a lot more wisdom and experience about how we could save $1 billion a year by doing it. If you look at Texas as an example and use $1,000 a case as an estimated cost, they could save $69 million a year by getting the misdemeanor marijuana cases out. And nationally, it's a stunning, because we have 660,000 marijuana arrests nationally. And the racial disparity in these cases is dramatic as well. So in King County, we set up this diversion plan, and the way it came about was the office I used to run, the Defender Association in Seattle. We had a project that was called the Racial Disparity Project, which was initially federally funded. And we put on a presentation at a dinner meeting of criminal justice people, including the elected prosecutor, about how what was happening is that people of color were being stopped for traffic offenses, and then they were getting fines that they couldn't pay, and then they were losing their license, and then they were getting criminally prosecuted for driving with a suspended license. The elected prosecutor said, you know, I totally get that. If I have a ticket, I can go pay it, or if I want to contest it, I can go contest it, and I know how to do that. But if someone has a job that doesn't let them go down and spend time in the courthouse talking to a magistrate, they're not going to be able to do that. And so he basically told his chief of staff to sit down with us, and we worked out this diversion program, which then everybody else jumped on it, and it saves $2 for every dollar invested, cuts the jail population. It cut the public defender budget by $300,000 the first year because we had fewer cases. Almost everywhere there's court rules about you have a right to a lawyer as soon as possible and at critical stages. We have a court rule about arraignment that counsel shall be assigned unless there's a knowing voluntary waiver. Most states have some rule like that, but they're often not followed. We made an effort to change and did get the court rule changed, not as fully as we wanted, but we got this language put in that the court shall make a thorough inquiry of the defendant's understanding before accepting the waiver. And that's not just, did you read this piece of paper that tells you you have a right to a lawyer? It has to be something more than, do you understand your rights? The thorough inquiry language we took from a case that the U.S. Supreme Court did in World War II called von Moltke. I love this case, and I teach it in all my classes because a German citizen accused of espionage was actually tried in a federal court and not in Guantanamo. And the issue that went up was she didn't have a lawyer when she pled guilty, and the government took the position that, well, she had the advice of a lawyer because the people questioning her were FBI agents who were lawyers. And the court said, no, there has to be a thorough inquiry by a judge. So defenders should be meeting with their clients, advising their rights. Judges should not be telling the defendants to go talk to the prosecutor, which I've seen in many places. The judges should be talking individually with defendants to make sure they understand their rights, both in terms of having a lawyer and having counsel. If you don't have counsel and there's an abbreviated process, there's no way for the defendant to understand what's going on. Steve Singer talks about basically client-centered representation, and of course they aren't even clients if they don't have a lawyer. And there's nobody to negotiate the plea for them or advocate for them at sentencing if they decide to plead guilty. And of course, if the client has mental health issues, they're not going to be recognized. I represented a woman on a motion to set aside a plea who was developmentally disabled. And the judge asked her when she pled guilty without a lawyer, have you talked about this with a lawyer? And she said, yes. Well, the lawyer she talked to was the prosecutor. And nobody realized that she was developmentally disabled. And as soon as we presented that, we were able to set aside the plea. So what can you do about this? Well, one thing you can do, and this is what I've been trying to do in various places, Washington and Kentucky in particular, is meet with the judge to try to get the judge to realize that lawyers have to be appointed. You can also take appeals, you can take writs, you can have move to set aside probation revocations. Of course, you need a lawyer to be doing all this. You can file judicial conduct complaints, try to identify allies. In Washington State, I was able to persuade, just by going to talk to people, judges to start appointing lawyers who hadn't been doing that before. And so this one judge, when I asked him how it's going, he said, well, things move much more smoothly. It improves communication. It's a fine thing for me, but especially for the defendant. It's a change I wish we had made long ago. And when I first looked at that court, people pled guilty without a lawyer, and there was no lawyer in the room. And there was a clerk who wore a jacket saying police volunteer, and it was horrible. And when I went back after this, I found that the public defender was there, represented everybody, and nobody pled guilty. Okay, I hope that was not much more than 6 minutes. Now I'm going into standards. Starting in 1982 in King County, in response to some media attention to the municipal court being overwhelmed, the King County Bar Association set up a task force of leaders and developed a set of guidelines. Shortly after that, we had a State Defender Association established, and we got a small ABA grant, and we developed standards, and then we got the State Bar to adopt those standards, and then we got the legislature to, I'm really compressing a lot here, we got the legislature to pass a law requiring local governments to have standards, referring to the State Bar standards. Then we got the City of Seattle City Council to pass a resolution that there had to be a caseload limit for public defenders. And then 17 years later, they passed that in a law, and I think it's the only law in the country in a city that's in effect now limiting caseload for defenders and adopting the 10 principles. Then the State Bar got involved, the Washington State Bar Association, and they recommended a rule that required standards. And then we had a case called A&J in the state Supreme Court, in which an appointed counsel with hundreds of cases a year pled a 12-year-old kid to a sex offense after spending 1 hour on the case. And the Supreme Court reversed that and blasted that lack of preparation, lack of investigation, and said that the standards could guide them in effective assistance. All this time, there was lots of media attention, both in terms of substantive coverage, op-eds, editorials, and features. A lot of that we were able to produce ourselves and get people to do, and other things the reporters did on their own. This is a series of articles in 2004, really outstanding articles by the Seattle Times, made a tremendous difference, is still having a ripple effect, and documented high caseloads by really what I call for-profit contract public defenders. The ACLU brought a lawsuit in one of those counties that was documented, and the settlement of that lawsuit involved setting caseload limits, requiring investigation, requiring supervision. And then they brought another case against 2 cities, which is now pending in our federal court, waiting for the judge to make a decision. And one of the outstanding things about this is that the U.S. Justice Department has filed what they call a statement of interest in the case, saying, we're not going to tell you what to do, Judge, but if you do decide that the cities are not doing what they should, you really should have a monitor, and here's all the things you ought to do to make that happen, and you have the authority to do that. And so we're optimistic about that. The Supreme Court, after A&J, decided that there ought to be a rule, and they passed a rule saying that before a lawyer is appointed, the court shall require the lawyer to certify that the lawyer complies with standards. Now, they said standards to be approved by the court, which hadn't been approved yet. And so they asked the state bar to develop those standards, and we have this Council on Public Defense, and we did that. We also developed performance guidelines and recommended standards to be incorporated in the rule. A year ago, a rule was implemented without numeric limits. The rule basically said you shouldn't take more cases than you can handle. As of October 1st of this year, the felony and juvenile offender limits took effect. The State Office of Public Defense is doing a case weighting study of misdemeanors, and the misdemeanor caseload limits are going to take effect in January of 2015. So the standard says, and this is now in effect, that the lawyers have to have the time and effort necessary to ensure effective representation and quality representation. The court, in its court rule, 3.2 standards it's called, requires certain standards to be certified, and others are to guide lawyers, and they specifically say to address the issues of A&J. The ABA 10 principle number 5 talks about controlling workload. The specific number for misdemeanors is going to be either 300 or 400, depending on whether case weighting is done. By the way, since I'm going so quickly through this, if you want this PowerPoint, I'm happy to provide it. Examples of some of the excessive caseloads that we had as recently as when this report was done in 2011 or 12 is one lawyer doing 1,700 cases a year. And of course, that means you got about an hour per case. That violates the ethics rule that you have to be competent and thorough. It's not fair to people. It undermines respect for the court when you have that kind of thing going on. And I wanted to point out that when you have a reasonable caseload, it actually makes a difference, aside from the client feeling like the client's actually being heard. In Seattle Municipal Court, where there is this 380, which is still a lot of cases, but 380 limit, in non-traffic misdemeanors in the entire state, there were 6.7%. But 9% of all the acquittals came out of that court. And in terms of charges, 24% of the charges result in guilty findings, which is pretty amazing. Of course, that means a lot are dismissed or otherwise gotten out of there. But statewide, it's 41%. So when you have a reasonable caseload, you can do almost twice as effective a job, is my conclusion, than if you don't. If you have an excessive caseload, there's not going to be investigation, there's not going to be a motion practice, people don't go to trial, they don't advocate for their clients at sentencing, they don't address immigration and other consequences, and of course the clients don't trust them, and it only gets worse. So what can you do about it? You can build alliances to address all of these issues. You can use the ethics rules, you can develop other rules, you can get local ordinances to be changed. You can bring litigation, whether it's a motion to withdraw from because you have excessive caseload or the systemic litigation that we've had. And then you use all the bar resources, the ABA resources in particular, that have been great, and then local ones. Use these publications that Norm Lefstein led. I want to close with these remarks from William Hellerstein, because he said these things in 1970, saying that the misdemeanor courts were an abomination, and what he said was that defenders have to work on this problem. And one of the huge problems, I think, nationally is defenders and appointed counsel who don't say no and don't resist. And he said it's time for all of us to turn our energies toward improving the criminal court process, and particularly on misdemeanor cases, and that we can't do 2-minute arraignments and 7-minute trials and call ourselves lawyers. And then, of course, I like to quote Margaret Mead. I usually ask my students, do you have any idea who Margaret Mead was? And of course, every year it's tougher and tougher to get people who do, but thoughtful, committed citizens working together can change the world. I hope that wasn't too much over 12 minutes, and be happy to answer questions when we get there. Thank you.